Hello friends, a very good evening. In our series on the income tax cases deliberations, today we have come with a matter in which the assessing officer passes the assessment order without giving the right of the assessee, which the assessee is entitled to during the assessment proceedings under the various provisions of the Income Tax Act, and raises a huge demand. And after filing the appeal of the assessee is not taken up for hearing by the CIT appeals for a period of 4-5 years, and at the same time the department starts the recovery proceedings against the assessee. So in that circumstances, when the demand of the assessee has been created with no fault of the assessee, what is the recourse available to the assessee? Although the recourse which is available to the assessee is also not easy and very costly affair, and it cannot be adopted by every assessee, but this case gives a insight that what the assessee can do in such type of cases. The name of the case is AMUDHA versus Income Tax Officer and others, and this case has been reported in 467 ITR at page number 299, and the matter has been decided by Honorable Madras High Court on 3rd January 2024. Friends, the assessment here is related to the assessment 1819. In this case, there was issue related to section 45 that talks about capital gains, and section 50C which talks about special provision for full value of consideration in certain cases. The assessee has sold some property, the registry was done, the sale deed was executed, and the sale consideration was below the stamp duty valuation. During the assessment proceedings, the learned assessing officer was of the considered view that the stamp duty valuation is the fair market value, and the assessee was saying that the actual sale consideration is the fair market value, and if the revenue is not satisfied with the sale consideration, then the revenue can refer the matter to the D.V.O. under section 50C read with section 55A. The matter was referred back to the D.V.O, but without waiting for the report of the Departmental Valuation Officer, the assessment was done and the demand was created, meaning thereby that the assessee was precluded from the report of the D.V.O, and the assessment was done without the report of the D.V.O, which was the right of the assessee. The assessee filed the appeal to the CIT appeal, and which was not taken up for hearing for a long period of time, and at the same time the assessing officer was initiating or pressing the recovery proceedings. The prejudiced assessee filed a writ petition into the High Court, and the High Court said that in the present case that it was the statutory right of the assessee to get the report of the D.V.O through the income tax officer, which was denied to him. So in the present case, from the facts and circumstances of the case, the assessee had been put to a great prejudice without any material to support that the guideline value or the stamp duty valuation is the fair market value. The court said that this is a fit case to give a complete interim stay on the outstanding demand till the disposal of the appeal by the appellate authority, and at the same time the CIT appeal was directed to dispose of the appeal within 3 months from the date of the order, and said that until and unless the appeal is disposed of, the demand cannot be pressed against the assessee. Friends, although this is a very welcome judgment through a writ petition, but for every assessee it is not possible to go for a writ, because the facts of the case are always different, And sometimes it happens that the writ petitions are not entertained on the ground that the assessee has the alternative remedy, and the chances of getting the full stay are very weak nowadays. At the end of this video, once again, I am repeating the name of the case. The name of the case is AMUDHA versus Income Tax Officer and others. And this case has been reported in 467 ITR at page number 299. And the matter has been decided by Honorable Madras High Court on 3rd January 2024. Thank you, friends.